So I take it you all are here to get more information on how to start your business. So is everyone looking to open a new business or start a new business? Is that ideally what your goal is after today? Okay. Well, today we're just going to talk about as Jimmy mentioned, the different legal structures. What structure may work for you, whether it's an LLC, whether it's a partnership, a sole proprietorship, and we're just going to go through the different entities so that you can see, based on your goal of your business, which actual entity would work for you. And we are going to start. Okay, so as I mentioned, getting started, we're going to talk about the different structures of a sole proprietorship. Partnerships, there are several different partnerships. There's a general partnership, limited partnership, limited liability partnership, and then we'll head into corporations. In Connecticut, there are two basic corporations. There's an S corporation and a C corporation, and then we'll finish off with limited liability companies. Each of these business structures have their own unique way of being formed, the way the day-to-day business is to be run, and the different rules and regulations, whether of the state or the town that you're actually practicing or running your business in. This just identifies 6 common aspects that differentiate business forms. There's taxation. The business structures are taxed differently, and we'll get into that. Liability, there's different liability with each of the business structures, different risks and control factors, continuity of existence, how long the business will stay in existence, whether or not it will dissolve with the death of a partner or an owner. Transferability, how can you transfer ownership from your legal structure to someone else? And then there's expense and the formality of running the business. How formal or informal the business has to be run, how expensive it is to run the business or form the business or maintain that business. And we'll get into all of those pretty shortly. Okay, first we'll start off with a sole proprietorship. You guys heard of a sole proprietorship before? Any ideas of what that is?
All mine.
All yours. Basically, yes. A sole proprietorship, it's basically an entity that really has no separate existence from the owner. For example, my business is a sole proprietorship. And what that means is I am solely the owner, I am solely responsible, and there's no one else that can be responsible. And in terms of a sole proprietorship, it's one of the simplest business structures that you can ever form. Basically, you open your business and you start running it as a sole proprietor. Sole proprietors do have to register with the town in which their business is run. So if you run your business out of Hartford, you have to file what we call a DBA, doing business as. So I would be Tanisha St. Bryce, doing business as Tanisha M. St. Bryce and Associates. I'm personally liable for any malpractice. My creditors can not only attack my business assets, but they can also attack my personal assets. So they can come after me. I know people are like, why would she do that? They can come after me for my home, my car, my boat, anything that I have, they can come after me for. I hold no property in my name. And it basically, the way that my legal firm is set up is I have to have a certain amount of malpractice insurance anyhow in order to run it, and my car, my house, anything like that, it's not in my name. So they will only be limited to assets that I own. So they can't go after my spouse, they can't go after my children, or my family, they can only go after what I personally hold. And currently I personally hold nothing but my business. So they can attack my business assets. But then you'll find later on, any legal entity, the creditors are subject to your business assets anyhow. Now, the more property you own, the more assets you have, obviously you want to protect it, and that's when we'll get into the LLCs and the corporations and the limited partnerships.
So the car is not in your name,
My car is not in my name.
but you use it for business?
I use it for everything.
Well,
But that doesn't mean that I have to own it. I use it for I use it for personal and business. As a sole proprietorship, there's really no differentiation between when I do my taxes, I still have to, whatever my business makes is personally, I just file as a regular individual. So there's no separate tax returns. Anything that is filed, it's basically income. So I get charged an unemployment tax because I'm considered to be self-employment tax. I'm considered to be self-employed, so I have to pay those things, but it's not a separate tax return. So it's your own tax return, so it really doesn't matter if you use it for business or personal, you're still a sole proprietorship, so it's really no differentiation. The only difference is I'm doing business as under a different name. It's what we call a fictitious name or trade name or a doing business as, a DBA.
Have you created a personal LLC to protect your assets?
I have not. I have not. I mean, that's something too in which, as you determine, you know, I've been practicing this way now for the last 10 years almost. And as you determine, or as you hold more property, or as you subject to more exposure or liability, I guess you can always change your mind. Like, I can always decide if I wanted to now formally form an LLC for myself. Costly, it's more cost effective to do a sole proprietorship for me right now. I do have to have malpractice insurance. I have to have general liability insurance already, which covers most of my structure. And I'm the only attorney that's working in my practice right now. So I don't have to have, I'm not really concerned in terms of my personal assets being attacked. To be quite honest, my home is in my husband's name, my house, my cars are in my husband's name, and it's always been like that. So I've never had reason to, right now, form an LLC. And as you'll see later on, LLCs, you have to pay yearly entity tax fees, you have to do annual reports. It's more of a structured legal entity than a sole proprietorship. Again, a sole proprietorship is the most simplest, easiest way to do it, but obviously if you do have assets that you're concerned about, it's not the way to go.
Okay.
A sole proprietorship can operate under the name of the owner, so I can just operate as Tanisha St. Bryce, or I'm Tanisha St. Bryce and Associates. You can pick any name that you want, doing business as. So you can say Tanisha St. Bryce doing business as ABC Law Firm, and that can still be a sole proprietorship. It's a popular form due to the simplicity. Again, people don't have to file forms, they don't have to register with the Secretary of State, they only need to register in the town in which they conduct business. If you're in Bloomfield, Hartford, and East Hartford, you have to register in all 3 towns. The advantages of a sole proprietorship is you have the least government rules, as I indicated, and regulations which affect it. The owners have complete control over every aspect of the business. So I don't have a partner that I have to confer with. I can make the rules, set the rules, and it is what it is. There's no voting, there's no formal meetings, it's just the one person that is the sole proprietorship, and it's easy to start up, and like I indicated to you before, you can potentially graduate to a more complex business entity such as a LLC or a limited liability partnership, etc. But we can hire employees as a sole proprietorship just like any other business structure. So you can run the business just like any of the other business structures that we'll get into in terms of employees. Some disadvantages of a sole proprietorship is, like I said before, sole proprietors remain personally liable for all business debts. So there's really no differentiation between a business debt and a personal debt. They're going to come after the person in charge. If the business runs into financial trouble, once again, the creditors can attach your home, your cars, any valuables that you have, they can attach that. Sole proprietorships are rarely survive the death or incapacity of the owner. Like I explained before, if I passed away, then there's no one else there's not me to do business as. So that's basically the end of my firm. However, can get a little bit more intricate in terms of referring or selling the clientele to a different law firm. So it's not exactly, you don't always die with the sole proprietorships, but for the most case, generally speaking, you do. And one of the other disadvantages is when you have LLC or corporation or LLP associated with your name, investors tend to feel secure in investing in your company versus a sole proprietorship. Although I do have a separate bank account for my business and I run it that way versus my personal, we don't have to. So funds can be commingled and often are commingled with sole proprietorships. It's no law that says they can't do it. Personally, I mean, because you're going to be legally liable personally as it is. However, I'm mandated by the state of Connecticut as an attorney to have separate funds for clients' funds. Those can't be commingled, and we're regulated with that. And I also have my own business operating account. So it is separate. I don't even have my personal bank account even in the same bank as the business bank account. And whether you're a sole proprietorship or any other entity, it's best that you do not commingle funds. And later on, you'll realize why, when you're an LLC, a corporation, why you should not commingle funds. Exactly. When you commingle funds, you set yourself up to be personally liable, regardless of whether you're LLC or LLP or corporation. Any questions at all on sole proprietorships? We are going to go into partnerships.
I know I'm gonna have a question on that. We can talk about the liability. I just don't know, just tell me when to ask.
The liability as to?
So the area that I'm going into, it's like you said, you have your malpractice. We have the errors and omissions, and we're liable for 30 years after the job is done.
What, if I may ask, what field?
Environmental.
Okay.
So we have a 30-year liability on every job.
And then you would have your errors and omissions, but you obviously have to keep it, and there's even a tail after you go out of business or after you close or dissolve the business. There's something called a tail insurance that covers you for certain years after.
Right, because it's after each project, they can come 30 years later.
Right. And in your field, I can predict that the E&O, errors and omissions insurance, would be costly. As is in the more work you do, the greater your insurance usually becomes, because now you have more exposure. So if I do one job, my exposure is only one client. But if I have 500 clients, now my insurance is going to go up because my exposure for lawsuits grow. That's the reality of it. That's how it works. I mean, and sometimes, like in our field, sometimes it goes up and then it plateaus. But then as you keep growing and you keep growing, it starts to go up some more. So unfortunately, you can see increments of at least $500 to $600 a year increase, and that's all due to the exposure that you have, what the insurance companies consider exposure. Partnerships. A general partnership is defined by Connecticut statutes as the association of two or more persons to carry on the business as co-owners for profit. So a partnership obviously has to have at least two owners to carry a business, to carry on a business together. There's no formal written agreement required to form a general partnership. Basically, in Connecticut, what the law states is that if you have the intent to work together, have the intent to form a partnership, that's all, the mere association is all that's necessary in order to form that partnership. Rights of partnerships, however, can be changed or can be different from what the state statutes actually say if there is a written agreement. So if there's a written agreement and it basically outlines how the partnership is to run, what the percentage is of each partner in terms of their ownership in it, that is supersedes what the Connecticut General Statutes say. In the absence of a written agreement, Connecticut law provides that all partners are general partners and general partners control equally. So they both have equal say, or they all have equal say in the general partnership, absent a written agreement.
Sounds like a prenup.
The actions of one partner binds all the partners. So if one partner enters into a contract, the partnership has just entered into a contract. They share the profits equally, and they are taxed at their individual tax rate, which is different from corporations and buildings. And typically the partners share liability, and they are exposed to what we call joint and several liability. And what that is the creditors can come after both partners if they choose to, or they can come after an individual partner if they choose to. And that's what we refer to as joint and several liability. So they can jointly sue both partners or all partners, or they can say, you know what, that partner has all the money, that partner has all the control, we're only going after that partner, and they can do that.
And that's called sever?
Joint and several liability. The advantages of a general partnership is it also requires very little paperwork. It's almost like a sole proprietorship, but with two owners or more. It has less government regulations and supervision, and you can dissolve it at any time. Some of the disadvantage of a partnership is that the partners are liable for the other partner's wrongdoing, or it can be dissolved upon the death of one partner, because then it will no longer be a partnership. If there was only two and one died, now it's a single member entity. The partners are liable for the other partner's negligent actions, so if they do something negligently, that exposes their liability in terms of the one or the other. So it's always important to, when you're entering a partnership, to make sure that your partner is competent, to make sure that you trust the decision-making that that partner makes, and also that you have a written partnership agreement. It's important because that written partnership agreement is basically the rules on how that you're going to run your partnership. So when there's conflict in the partnership, you can go to that agreement and basically says, this is what, in the case we disagree, the partnership agreement says we do X, Y, Z. A partnership is not conducive with a company or for a company that has many different owners. It just gets too complicated when there's many different owners, and then you'd have to go into one of the other entities such as an LLC or a corporation. Any questions? Okay, so we're going to get into limited partnership. A limited partnership is defined as a partnership formed by two or more persons under the law of the state, and they must have one or more general partner and one or more limited partner. The general partner has to have one or more general partner that has unlimited liability. So in order to have a limited partnership, you have to have a limited partner, a general partner, and a limited partner. And the general partner has unlimited liability. So their liability, their exposure is not only what they contribute to the partnership in terms of how much they pay or what their percentage is, their liability is unlimited. The limited partner has limited control, therefore they have limited liability. The general partner is responsible for the day-to-day running of the company. The general partner can be a corporation, it can be a person, or it can be any other kind of entity. It doesn't have to be a human person, it can be a corporation or another company. The limited partner does not participate in the running of the business, but they can elect a new general partner. So they can vote for the election of a general partner. the limited partner's liability is only to the extent of his or her capital contribution. So only what they contributed to the company is what their exposure of liability is. However, again, we're getting into almost like piercing a corporate veil. If they act like a general partner, if they're able to make day-to-day decisions, if they're able to, if they basically act as a general partner, day-to-day decisions, you know, how to run the company and make important decisions, then now they're considered to be a general partner. And at that point, they can be exposed to unlimited liability as well, just like the general partner, regardless of the fact that their capital contribution may be smaller than that of a general partner, by the fact that you're acting and putting yourself out there as a general partner. So to the world at large, they see you in the forefront. You're a limited partner, but your clientele or the world at large see you as the person that they talk to on a day-to-day basis, or the person that's making the decisions of the company. That in particular is almost like piercing what we call the corporate veil, and that will open them up to could open them up to unlimited liability. With respect to a limited partnership, in the agreement, it specifies the length of the existence of the partnership, when that partnership is to expire. It's in the written agreement. Some advantages of the limited partnership is it's easier to attract investors for obvious reasons, because there's only limited liability for investors that only contribute capital. This way it allows them to be able to invest in other companies without having to be involved with running the day-to-day businesses, but then they do benefit from their capital contribution in the different companies that they're involved in. It also allows for the general partners to focus their efforts on running the business. So we have the limited partners that can contribute but not run the business. We have the general partnerships that really just have to focus on running the day-to-day business of the limited partnership. Limited partners can leave or be replaced without having to dissolve the limited partnership. Some disadvantages: it does have filings and formalities and state requirements. An individual acting as a general partner, as we discussed, can assume liability under the partnership, unless the partner forms, an LLC or corporation. Then, as we get further into LLCs and corporations, acting as a general partner, if you're formed as an LLC or corporation, then you're not exposed to the same liability as if you were acting as such in a limited partnership.
So the limited partnership has to file with the state of Connecticut as a business, and there's an annual business fee.
There's a filing fee of $120, and typically there is, because you usually have, when you file with the state of Connecticut, they usually require you to do annual reports, which are fees. Usually the report's about $10, but I don't think it's as much as an LLC, which currently there's an entity tax associated with the LLCs, which are $250 per year. Honestly, I'm not sure if it applies to the partnerships as well, and I can look at a fee schedule and see if that is something that applies. But it is regulated by the state. Now we get into the limited liability partnerships, which is primarily designed for professional practitioners such as attorneys, accountants, doctors, etc. And there must be at least 2 members for a limited liability partnership to take place. In a limited liability partnership, the liability for contractual obligations, and well, actually the partners are obligated for the contractual obligations of each of the partners and employees. The assets of the entity are exposed to liability. So not just the personal liability is not there. Like a sole proprietorship, there's no personal liability with respect to a limited liability partnership, but all the assets of the partnership. So if the partnership owns the building that they are running out of, and any of the bank accounts or any of the sometimes it depends on what kind of business it is, any of the invoices or things that they are to be paid on, those are subject to those are the assets that are subject to liability. The individual partner, however, is not directly or indirectly liable for the negligent acts or wrongful conduct of another partner, employee, or representative of the partnership. There's no personal liability for the debts of the partner or the debts of another partner under contract theory. So there's no personal liability. Again, whatever I contribute, even though it's not my wrongful act, if my partner was negligent, then my business assets, because your partner's business assets are typically your business assets, because we gone in and whatever my capital contribution is, it doesn't matter. If my partner was negligent or committed some type of malpractice, then my business assets are also on the line. Not just, I own only 20%, my whole 20% is on the line, in addition to my partners. A limited liability partnership is required to maintain professional liability insurance in the amount of at least $250,000. That sounds like a lot, but obviously most entities carry at least $1 million more in terms of malpractice insurance or limited liability, professional liability insurance. Some of the benefits of another benefit of the limited partnership is that there's what we call a pass-through taxation of a partnership, and what that is basically, as you'll see later, the corporation is taxed twice. The corporation is taxed on its profits, and then when it distributes profits to or salary to the owners, they also have to pay taxes on that as income. So basically, it's taxed twice. With the partnership, that's not so. The partnership, the partner is the one who's taxed on the income or the profits. It's not taxed. The partnership doesn't get taxed for it. You look like you have a question. You must have a certificate of limited liability partnership with the state of Connecticut, and at the end there are forms that you'll be able to see what these forms look like that you have to file with the state of Connecticut. So to form a partnership or limited liability partnership in Connecticut, you do have to file a certificate of limited partnership with the Secretary of State. The partners have authority basically to decide how they will individually contribute to business operations, the managerial duties. They can divide it up equally, or they can choose not to divide it up equally. That is the benefit or flexibility, should I say, of a limited liability partnership. In a partnership, someone who has made a financial contribution or has a financial interest in the company, they can elect not to have authority over the business. They can be what we call almost like the limited partner. They can elect to just make their financial contribution or their capital contribution to the business and have no decision making. They can maintain their ownership rights based on their percentage also in the interest in the company. So again, they can be a partner, but they can choose to say, okay, I'm going to be your partner, almost like a silent partner. I'm going to contribute and I'll provide finances, but you're the one who needs to run and operate the day-to-day business of this limited partnership.
Significant delay.
Yeah, I do it and then I do it again and it just skips it. We discussed some of the advantages already of the partnership. The partnership itself is not responsible for paying taxes, as we discussed. It is normally individuals in a partnership are liable for filing their own personal income taxes. They also will get taxed as a self-employment tax because they would be considered to be self-employed. The credits and deductions of the company are passed through to the partners, as we discussed earlier, and filed on the individual's income tax return. Some disadvantages are, because of the unique structure of the LLP, taxing authorities in some states, they do not recognize the structure as a non-partnership for tax purposes. Not in Connecticut, they do. This could possibly be a disadvantage for partners who require special tax consideration. Unlike general partnerships, Limited liability partnerships are not recognized as legal business structure in every state, as we just indicated. Some states limit the creation of a limited liability partnership to professionals such as doctors and lawyers. And there's also what we call professional corporations for doctors and lawyers, and we'll get into that shortly. And what this is saying is, for the protection of the overall integrity of the company, you should create a partnership agreement. And again, it doesn't matter what kind of legal entity that you form, you definitely should have a partnership agreement or operating agreement as we get into LLCs, bylaws. Those are the rules and regulations of the entity, and it's always wise to have something written, because if you ever had to go into the legal arena, you ever had to go to court, what the judges look at is what was in the four corners of that contract. It's really hard to say, well, we agreed to doing this, because one partner could be saying one thing, the other partner could be saying another thing, and so if you have to get the courts involved, it's better to have something in writing, because then the court can interpret what was in writing and they can legally enforce it. What was in your mind and what was in your partner's mind cannot be legally enforced, because although you thought you were on the same page, obviously you weren't on the same page, so sometimes what your partner thought was the case or what you thought was the case can conflict. So it's always best to have in writing, because if you do have to turn to the courts, they can read it, interpret it, and enforce what was on the written document.
What's a special tax requirements? What does that mean?
This could be a disadvantage for partners who require special tax consideration. When they refer to special tax consideration, it could be an array of things. For instance, let me just try and think of a scenario where special tax consideration. The purpose of the limited liability is for one of the reasons obviously is the pass-through tax. But if some states don't recognize them as a limited liability partnership, then they may not qualify for the pass-through tax, and that is the special tax benefit that limited liability partnerships are looking for. And so if they're just deemed to be a general partnership or even a small corporation, then they can be taxed.
Yeah.
Now we get into corporations, and a corporation is an independent legal entity separate from the people who own it, control it, and manage it. So for all intents and purposes, the corporation is viewed as a legal person. So the corporation it's separate, as in a sole proprietorship. The business is not separate from the owner. In a corporation, the business is its own legal entity, and that as a legal entity, the corporation can enter into contracts, it can incur debt, so it can borrow money, and it can pay taxes apart from its owner. In fact, it does pay taxes apart from its owner, because a corporation has to file a corporate tax return, in addition to the owners having to file their own individual tax return. In Connecticut, there are two basic forms of a traditional corporation. There's an S corporation and a C corporation. The S corporation is taxed somewhat like a partnership, while the C corporation is the most formal for tax purposes. Usually the S corporation is a small held corporation entity. A lot of times it's we refer to as almost like a family business would be considered an S corporation. Officers and directors are liable for criminal acts of the company, and officers and directors have a fiduciary duty to the shareholders. So if someone, a representative of the company, acted criminally, negligently, the officers and directors are responsible for that, because it's a business, it's a corporation. They have the responsibility of making sure that it runs properly and overseeing the business. So if they had to sue someone, they don't sue them in their individual capacity, they sue them in their corporate capacity. So if you were wronged by someone who works for a corporation, who are you going to go after, that individual or the corporation? Really, a lot of times you go after both. You go after them individually, and you'll go after them, the corporation. Now, officers and directors have what we call officers and directors. Actually, there's insurance for officers and directors that covers them for this. And so when they are sued, that's the insurance kicks in. And fiduciary duties to the shareholders. What that means is they have to make the best legal decisions, or any decisions, the best decision of running the company, making sure that they're doing what is necessary for the company to be profitable, to make sure that if at all possible, the shareholders' shares are increasing rather than decreasing. So they have that fiduciary duty, and they breach that fiduciary duty to the shareholders. Guess what? The shareholders can sue the corporation as well for breach of fiduciary duty.
Who pays the officers and directors premium?
The corporation. Connecticut requires at least one officer and one director to form a corporation. Corporations do pay taxes on the net revenue earned, and then the owners and shareholders pay a tax on the dividend that's paid out to them. And if they draw a salary, they have to pay taxes on the salary that are earned as well. You have to elect in the corporation. There has to be a board of directors to oversee the policies and the day-to-day running of the corporation. There must be a financial operations, a financial report. So that's important when running a company or corporation, I should say, that the finances are in order. You can be audited. The state really takes an interest in the state attorneys general. You have to file your financial reports with the state attorney general. So it's best to keep as accurate finances as possible. And for C corporation, profits are taxed separately from its owners. So they are double taxed. S corporations, they're passed through onto the shareholders. And again, S corporations are smallly held corporations. So it's usually something like a family business. And they do take the benefit of passing on the taxes onto the shareholders. Liability of the owners is very limited. Usually in a corporation, the only way that an officer or a director or someone could be liable is if they really acted misconduct in terms of negligently and grossly negligent conduct, criminal conduct, anything that was intent, anything that was done to harm the company, or anything done outside of the official capacity of their official capacity of the corporation. So anything that was done that was outside of the scope of the business and they've done it negligently, then they can actually be personally liable.
Yeah, but I'm thinking SISTI.
I'm sorry?
SISTI, Colonial Realty.
Uh-huh.
That didn't work so good.
Well, it's a case-by-case basis, but what you have to prove is that they acted outside the scope of their business capacity. I mean, there's things that actually happen. I mean, if you think about scenarios where someone acted in their personal being, you know, in terms of their behavior, the way they may have treated someone, or some kind of grossly negligent act that had nothing to do with the day-to-day running of the corporation, or had nothing to do with the business. It's really hard to hide behind the corporation if you did something outside of the scope of the corporation. I mean, it obviously also has to be gross, because something that was really, really big in order to be able to come after them, because that's the whole purpose of having a corporation. Now, if they say, well, I did this because I thought this would better the business, or I did this because of X, you know, it's entangled in the corporation somehow. But if it's your own decision, if it was something that we don't normally do in the business, this is not, you know, outside the scope of your business, we don't typically do that. You decided that on your own, you're going to be liable on your own. But it's rare. It is rare, but it can happen. It can definitely happen. Corporation, the advantage is it provides limited liability for investors. Although, as you mentioned before, if the corporate veil was pierced, and there's many different scenarios where the corporate veil could be pierced.
The mixing of the accounts and the money, and it's like, don't do that.
Right, and that's key right there. When you commingle, the court is not going to determine what part is yours, what part is the company's. Now it's all up for grabs.
Yep.
Malpractice remains with the corporation, so if you did something, in terms of malpractice, if you made a mistake, you did something that you shouldn't have done, you missed something and it hurt the shareholders or it hurt your customers, then the malpractice remains with the company. I thought I did it right, I overlooked it, I did it incorrectly, but I was working, in the capacity of my position at the company. Now that's where malpractice insurance comes in and doesn't open you up to personal liability. Profits and losses don't affect the owners, so profits and losses of the company don't affect the owners' tax return unless the salary is drawn. But then you can also say that with the sole proprietorship and sometimes a limited liability company, the profits and losses of the company as a sole proprietorship, you can claim that loss on your individual tax return. Corporation takes a loss, you cannot claim that on your individual, it's just a corporate loss, it's not an individual loss. So no matter how much money you have in that corporation, and even though your company takes a loss, especially if you're the owner of the company, you have personally taken a loss because your company took that loss, you cannot claim that loss individually in your taxes.
But you still get it as the corporation.
The corporation does.
As long as you get it.
And again, another advantage, credibility. And once again, this is businesses with LLC or corporation after its name tends to attract or be more appealing to investors, and that's only because they know of the formality. They know how it is closely watched by the state, and so a lot of times they're more apt to invest in a company that has LLC or corporation. The disadvantage is a corporation is one of the most expensive entities to maintain. And to incorporate, it's more expensive than any of the other entities. The paperwork consists of articles, bylaws, corporate minutes, and other annual report requirements to the Secretary of State.
You said the sole proprietorship, and which other one can claim the corporate loss personally?
Sole proprietorship and sometimes a limited liability company. What we call single member limited liability companies. You have to file a separate tax return for the corporation. Business losses can only be applied to the business. And there are many statutory rules that exist that govern the existence, structure, and other aspects of a corporation. Now we get into limited liability companies. Limited liability company is somewhat of a hybrid form of business entity that combines the attribute.
So, we did everything for the S Corp, right?
Yes.
Just point of information. The S Corp entity was around long before the concept of the LLC.
And LLC is fairly new in terms of
perspective. Are most businesses starting today choosing to go with the LLC versus S Corp?
They absolutely are. Because they have the benefits of the liability protection with the LLC. And it's cheaper, and you can have many, many members in the LLC. Nowadays, most of, especially the small businesses, are formed as an LLC.
So what scenario would there be to justify an S Corp versus an LLC today?
Well, I guess it depends on how many owners there are in the entity in and of itself and how it was run. Not a lot of businesses nowadays are starting S Corps. They're just not doing it anymore. It is an LLC. So in terms of what the business is, the protection, I think the protections are the same at this right now. It's pretty much the same. So I can't say it's better to do an S Corp versus an LLC. I can say it because it's cheaper to do an LLC, and the same protections that are afforded an S Corp and are afforded to the LLC, especially the pass-through. And limited liability, I mean, just going back there quickly, I form many LLCs, hardly any corporations. The most corporations that I do form is where the entity is going to be a not-for-profit organization. And then they form corporations so that they can be a 501c3. So that's usually the only time I see corporations. Other than that, we do mostly LLCs.
So 501c3s are always S corps?
They're corporations depending on whether you do it as an S Corp or a regular C Corp, but in terms of just forming a corporation in and of itself, so they're not always S Corps.
But it's always a corporation.
It has to be a corporation to have a 501c3. Although now there's some intricacy about LLCs, but for the most part, it's a 501c3 company or corporation.
Is it possible for an LLC to get a 501(c)(3)?
It is, but they have to be regarded as a corporation. Okay, so a limited liability company is combines a partnership and a corporation. The limited liability corporation is designed for the limited liability of a corporation, so they have the same limited liability that the corporation has, but they have the benefit of the flow-through tax, pass-through flow-through tax advantage. So I have that liability, I have the limited liability benefit of a corporation, but then I have the pass-through benefit also of not having my company be taxed and then me be taxed, but just having it pass through to the partners or the members, we call them, in a limited liability company. Like a corporation, members are not individually liable for the obligation or liabilities of the company. And if it's properly structured, it avoids the corporate level taxes. And typically they all avoid that. The members are the member or owner has a contractual agreement, and that's the operating agreement. Operating agreements are not required in the state of Connecticut. However, the operating agreement is akin to the bylaws for a corporation, and it basically states how the business is going to be run, how members will buy in, how the members will sell out, how the company will be dissolved. So the operating agreement is essential, although not required. In order to form a limited liability company, you have to file an articles of organization with the Connecticut Secretary of State. It's more flexible than a corporation, and it's well suited for companies with one owner. And typically, one owner LLCs a lot of times can be considered sole proprietorships, can be taxed as sole proprietorships. So if you're a single member LLC, you have the benefit of not having to file a business tax return, but you can file it as a sole proprietorship. You can file your taxes just without having to do a business tax return and your personal tax return. You can claim the income from your single member LLC on your regular taxes. Again, you have that self-employment tax that you have to deal with. It's less formal to maintain an LLC. You just file your minutes. Usually you have your minutes, you have your updates with the Secretary of State yearly, and that's about $10, which your reports are $10 usually a year, and then you have your $250 entity tax. There's not much administrative paperwork and record keeping with an LLC. Now, an LLC, it's easier, and I have a lot of clients that do this. They're an LLC, but they're single member LLCs, and what do? They have a business bank account and a personal bank account. However, they'll get their check payable to the business and they'll deposit it into the business, but then they walk around with a business debit card and, oh, I left my personal card at home, or I didn't transfer money, or I didn't do this. So they use the account for groceries, they use it to go to the movies, they use it for all of the wrong reasons. And the reason it's the wrong reason because, say for instance you were sued for whatever, you lose your benefit of limited liability because you're commingling funds. You're using the business account as your personal account. So at that point, you have you've lost your liability. And now your personal assets are exposed, your home, your car. Whatever you have, not only is your business assets up for grabs, but your personal assets are up for grabs also. So it's always important, and I always stress to clients when I do their LLCs, you must have a business account. If you don't have one, go out and get it. Yes, it's easy. I'm the owner, I'm the only worker, I'm the only one. It's easy for me to just do everything out of one account. Well, guess what? The purpose of filing for an LLC is for that protection. And I don't think people understand that. They think that, oh, I'm an LLC, I'm an official business. Well, you could be an official business as a sole proprietor. However, when you go into filing for your LLC, your main goal is to have limited liability. In order to keep that limited liability and limit it to your business assets, you must not use that as your personal asset. So I always tell them, write a check to yourself and then deposit it, pay yourself, and then deposit it into your business account. This way, if you were ever sued and they go into look at your records, they don't see a payment to Stop and Shop or, Lowe's or Home Depot. They see just business expenses in your business account, and therefore you're able to maintain your limited liability. The flexibility of an LLC is the statutes. The LLC statutes use the phrase unless otherwise provided for in the operating agreement. Again, always use an operating agreement. You always want to be able to turn to your operating agreement to figure out how you are to not elect members, how members are to be bought in, sold out, or how they're to leave, how the winding up of the business is to take place, which is the dissolution. And it also allows for the members of the LLC to basically say how it's going to be governed. Some advantages: it is less administrative work and record keeping, pass-through taxes that we discussed, no double taxation, and it can be set up with just one person, which would be like a taxes sole proprietorship. The disadvantages is it's not easily transferable from one state to another. So if you had an LLC in Connecticut, that LLC is not going to be recognized in New York. You have to, it's a state thing, and you have to set an LLC up in the state of New York. So that's versus a corporation. An LLC is not going to follow you. It's not easily transferable.
So if I'm living in the state of Connecticut and I go with the LLC in the state of Connecticut, but I retire in the southern state, but maintain and want to run the business, can I still run the business in Connecticut, or should I then set up an LLC in the state that I'm living in?
When you say run the business, is there like the business where there's an office in Connecticut? And
yeah, but if I move, the office would probably...
Okay, then you would need to set up an LLC in the state of Connecticut, New York, because you really have no sufficient contacts with the state of Connecticut anymore. So really governing your LLC...
So you technically completely dissolve this and move the assets to another
LLC in New York, right? It's not easily transferable because it's like a state recognized limited liability in Connecticut, and if you're not practicing or working or have a physical office address in Connecticut, then there's really no need to have a limited liability coverage in Connecticut.
When you said you can write yourself a check and deposit it, what do you write it for?
You can do it like payroll. You can do it as a draw. Most people say it is a draw.
Okay.
And it's always important too, when you have these things, these legal entities, to have legal counsel or really an accountant to help you legally structure your assets. It's very important to get guidance from an accountant so that you can basically maximize on your limited liability and maximize actually on whatever the business assets is possible. Managing members must pay self-employment tax, as we discussed.
So if you have an LLC in Connecticut and you're branching out, or let's say you had a corporation and you started doing work in tri-states, the corporation you can set up. You
can keep your corporation where it is
here because you can keep working anywhere else. So in the LLC you can still do that too.
You can, but if you don't have a physical office, in a scenario that Martin.
Right, but I mean, if you did stay here.
If you stayed here and you have a physical office here, but then you're opening up a physical office in New York, as long as you have sufficient contacts and you do have an office, just if you have the business here and you just move somewhere else, that doesn't mean now I have to go establish an LLC in New York because I moved to New York if my business is still here in Connecticut. My employees are still here.
No, but I'm saying the business is branching out.
Right, and you can expand, but you can, your head home quarters is here in Connecticut. You can leave it here and still operate under the LLC here. You may have to register your business in the state that you're in regardless.
All right, so I need clarification on the statement that members are not allowed to take a wage. So if you have an LLC and you have employees, those employees will be set up, you know, like any employee, you're gonna, you know, pay them
Their wages.
weekly wage, whatever, and take all the deductions out for them. But if you wanna take money out on the same weekly or bi-weekly basis, how do you go about doing that? How do you want, you know, I understand what you're talking about.
You make a distribution to yourself.
All right, so how's that different from what you're doing with your employees?
Yours is theirs is considered wages, obviously, you're taking out all their taxes, et cetera.
Yeah.
Yours is a distribution, it's not really considered a wage because you're not taking out your taxes, you're gonna pay your self-employment, your self-employment tax. So really, the LLC, the wages that come out are typically on the profit of the LLC. If there's no profit, you can still take a distribution, and when you do your taxes, you get hit, you know, with your self-employment tax, but it's not considered a wage for members, it's just considered a distribution.
All right, so you're writing checks to the employees for salary, and then you can write a check for yourself as a
Member distribution.
member distribution. But then for tax purposes, how do you?
You claim that member distribution is now your income, and so you obviously claim that when you do your taxes, and on top of that, you will pay your self-employment tax. Regardless of how much you take out, you will be hit as a member of the LLC self-employment taxes.
So is there a way to pay that on a monthly basis to the federal government?
Actually,
you don't have the lump sum?
there is. You can be set up like where you can pay quarterly taxes and anticipation of how much you would owe. And at the end of the day, when you do your tax return, obviously if you didn't pay enough, you'll pay the difference, or if you pay too much, you get a refund. I can tell you as a self-employed person, almost never pay them enough. And my accountant put me on quarterly, and it seems like doesn't matter how much you pay to them quarterly, it seems like in my situation, at the end of the year, I'm always owing the IRS and the Department of Revenue Services. But yes.
So if you use a payroll company for your employees, can that payroll company also handle your distribution?
That's a good question, I'm not sure. I don't see why not. Well,
Wouldn't that be your accountant?
no. A payroll company is, for instance, is a company called Paychecks. And what they are responsible for doing is writing checks.
No, I get that, but I mean, I get that for them doing the employee, but.
The accountant doesn't have access to your accounts. Now, the distribution in terms of a member LLC. Remember, if you're the sole member, then you could be considered sole proprietorship. So it's not as, it's easier for you to take a distribution. If there is more than one member in an LLC, now you have to have a consent from the other members that you take this distribution. So it has to be an agreed upon amount of distribution, and each member has to agree, or whatever the vote is that's in your operating agreement, that you take the distribution, and then the LLC will write that to you. I don't think that I guess the payroll company could, if you're paying them to do your payroll, I guess they could make that distribution to you. I don't really see why not.
Ours does our payroll. Our business owner, she has an LLC, so we're on payroll as employees, but she's also
On payroll as
Right.
employee.
So I don't put in her hours or anything, she just gets a distribution of it set every.
Right, so she probably just gets a set amount.
Right.
It's not necessarily considered a wage, she just gets where you can get your hourly fee, your hourly wage, whether you work or you don't work, and then they calculate the hours, so yours can go up or fluctuate, whereas hers just stays the same. So she can, you know, her consent can say, I get $500 a week, no more, no less, $500 every week. And so hers will, no matter how many hours she works, it will still be a distribution of $500 a week.
See, what I don't like about that is that now the owner of the LLC has to worry about, when they deposit it in their personal account, saving enough money and putting enough money aside for the taxes, et cetera, and not spending it. So that's why I'd like to have the payroll company
I got you.
be responsible for
So
doing
that they can take out.
So you know that it's all taken care of, you don't have to worry about it.
Right,
I
right.
can't tell you how many businesses get in trouble because
I know.
they don't put enough money aside for the taxes.
You're absolutely right, you know, and it is a good point. Even as, not as an LLC, but as a sole proprietor, every year, you know, generally speaking, your business grows and it continues to grow. So your first year of business, obviously the tax liability is not gonna be same as your second, third, fourth, and fifth year. So you go from maybe getting a small refund to maybe on $500 to $1,000 to going up to $7,500 or $8,500. And that's a big lump sum that a business owner has to pay. And do they have always $8,500 to write to the IRS? Yes, maybe, maybe not. You know, so it is.
Absolutely.
It is. And then the IRS, that's a whole nother entity because they can attach they definitely, if you own a home, they do put a lien on it if you owe them money. They garnish your wages. So the IRS has a way of getting their money. So it is important to realize that you do have to pay that at the end of the year. And that's why a lot of LLCs, what they do is have their accountant set them up for quarterly payments to the IRS. So after each quarter, you make a certain amount of payment. You just kind of anticipate what you paid to them last year, and what we do, and then maybe a little bit more, so that, you know, in the end, you're not stuck with a huge bill. Professional corporations. Professional corporation is only available to licensed professionals such as doctors, lawyers, and accountants. They have to be licensed professionals. Most states, and the reason for it, most states prohibit professionals from forming corporations under the regular corporation statutes for purposes of practicing their professions, because corporations, your liability is limited in terms of your malpractice. But states believe that licensed professionals should not be protected from malpractice under a regular corporation statute. After all, how many licensed professionals, doctors or lawyers, etc., that can just commit malpractice all over the place and say sorry? They hold you to a higher standard because it's a skilled profession and you're supposed to practice with the diligence and knowledge of a licensed professional. So therefore, you can't form what's called, you can't form a corporation because you don't have that limited liability of a corporation, but states such as Connecticut allow you to form what's called a professional corporation. And the difference is, states, this special statute that they have adopted, it permits professionals to incorporate the tax advantages of a corporation, but it doesn't allow them to have the limited liability for malpractice purposes. So they actually make it clear that practicing professionals in a professional corporation will still be personally liable for his or her malpractice, but you will get the tax benefit. So they carved out a special corporation for professionals. They said, you know what, we don't think that they should be able to hide behind corporation status and say, oops, sorry, committed malpractice. They can't hide behind that, but we still want to give them the tax advantage of a corporation. So this is how this is the result of professional corporation.
Why would they do that when they could do an LLC and be protected?
Some states don't allow an LLC, but even with an LLC, your malpractice, you're not, as professionals, licensed professionals, you cannot stand behind the limited liability for malpractice.
So if you're a doctor or a lawyer, you set up as an LLC, which should be protecting your, minimizing your liability.
It will minimize your liability in terms of your personal assets. It will. It's not gonna minimize your liability in terms of your profession of malpractice. We can't say, well, I'm a limited liability. What it does limit the liability to is our personal, they can't come after our personal belongings. If you're a limited liability attorney with a limited liability company. With the professional corporation, they're saying, look, you're not gonna hide behind this limited liability, this liability status as that a corporation would normally get. If you acted negligently, etc. With the limited liability, we're still on the hook for malpractice. But they just cannot come after our personal belongings. With the professional corporation, they also cannot come after their personal liability, their personal property, as long as they acted within, not negligently, grossly, wantonly, etc. It is limited to the scope of the but they still don't want to say, well, I can't be responsible for malpractice. Because remember, in the corporation holds the malpractice insurance. In a professional corporation, the individual holds the malpractice insurance. So I can be in a professional corporation and I can't say, well, I have corporate insurance, officers and directors insurance, so I'm straight. We can't do that. We have to individually hold our own malpractice insurance.
And we pay the premium?
And we pay the premium. Now, if it's an LLC, you can have in your operating agreement, and each attorney has to be covered in their malpractice. The malpractice or errors and omissions insurance specifies each attorney in that policy.
Is there a list of what professions are allowed to be in a professional corporation?
Doctors, lawyers, and accountants.
That's it?
Strictly limited to those three. So with the professional liability, there are tax breaks, so you can create a 401k plan for your employees with higher contribution limits. You can provide health and life insurance as a tax-free benefit to your employees. Tax deductions for disability insurance and dependent care. So you're kind of running it, have the tax advantages of a corporation. Perpetual existence. If one owner leaves the company, they can continue to operate without interruption. The disadvantages are limited in the amount that can be deducted for tax purposes in the business laws. There's a flat corporate tax rate that applies to PCs, whatever that is. It's just a flat corporate rate, and which reduces the company's flexibility in distributing the income. And the practicing professional is personally liable for their malpractice.
So if there being double taxation, you gotta pay tax as a corporation.
Well, they have several other tax benefits of a corporation, of the corporation, obviously. But yes, there is a flat corporate rate, which probably doesn't apply to regular corporations, but it's a flat rate that is applied, so yes. And then whatever is distributed to the individuals.
So they pay their personal tax.
They do.
Which you don't have in an LLC.
Which you don't have in an LLC, correct. And you don't have in a limited partnership.
So I still don't understand why somebody would go that way.
There are a lot of professionals that do professional corporations because there are certain tax benefits, even in terms of the 401ks and being able to have, because that's open to a corporation, and they can have 401ks for their employees with higher contribution rates. They can, the insurance issue, the factors of tax deductions for disability insurance, the dependent care, so they can have like a package that a corporation has for their employees.
So LLCs cannot do 401ks?
They don't really, no. I think there really are no. It's not called a 401k, it's called something else. It's some other structure, but it's not a 401k. I wanna.
An IRA, deferred compensation.
Or I wanna say a 403B.
Oh, there is a
something like
403B,
that.
yeah.
So,
And then there's the other one, the TP.
I was defer to the accountants for
Yeah,
that,
there's a TP
but yeah,
something.
there are other comparable or substitutions for the 401k that they have. As we're nearing the end, I don't even know.
I got a question on the LLCs.
Sure.
Are you at all knowledgeable on the advantages of setting up a Delaware LLC?
Well, a lot of people ask that because Delaware's laws are a little bit more lenient than most of the other states. However, if you don't have a business in Delaware, you can't set up an LLC in Delaware. You know, people can say, okay, I'm incorporating my business in Delaware because their corporate statutes are more beneficial to the owners of the corporation than a lot of other states. However, if you don't have a business in Delaware, I'm just incorporating in Delaware, but I'm operating my business here in Connecticut, Connecticut's law is going to, you know, if you were sued, they're gonna say, you know what, that person doesn't have sufficient contacts with Delaware. Connecticut law should prevail. And so a lot of people have the misnomer, oh, let me go and incorporate in Delaware because the tax benefits are better, the statutes are better, but you have to do some business in Delaware to incorporate in Delaware. Or else everyone would just go to Delaware and no one would be in their home state.
There's so many people that are doing it, you know, because there's
They
a
haven't gotten
whole,
caught yet.
well, there's a whole business structure in Delaware where they'll say, okay, we set up these buildings with mailboxes. So
Yeah.
so they're gonna have your mail there, there's phone service there, so they can, phone lines going into there.
And they do
And-
that so that they can have somewhat of a presence in Delaware and say, but you know, your principal place of business doesn't have to be in Delaware for it to be, you know, it's just where you have an office set up. It doesn't necessarily have to be the principal place of business, but you have to have some ties to Delaware. You have to have sufficient contact with Delaware in order to, so I have a P.O. box in Delaware, but my business is in Connecticut. The office is in Connecticut, my employees in Connecticut. I really don't have anything but my post office box in Delaware. You know what's gonna happen? When you're sued, you're gonna tell the people, well, the laws of Delaware apply because that's where I'm incorporated. And what they're gonna say is, their attorney's gonna say, you know what? Absolutely not. That's a facade. They have no business in Delaware. They do nothing in Delaware. So it's gonna be a battle and to first in the court say, you know what? Who has jurisdiction over this matter? And the attorneys for whomever is suing you is going to argue that Connecticut should have jurisdiction because you have no sufficient contacts with Delaware in order for Delaware to take jurisdiction over it.
Would sufficient, does sufficient automatically mean more than half, or what is, how do they determine what sufficient is?
And that's up to the court to determine what sufficient contacts.
So it could be 25%.
It could be. It could be if they're doing, 25% of their business in Delaware. It could be, but that's why it's sufficient contacts. You know, they would say half of your business has to be doing there, or 75%. That's why they came up with the term sufficient contacts with the state. And what is sufficient contact? Yeah, so I guess that is to be interpreted by the courts. Have to have sufficient. It is, and the law is up for for interpretation, and that's what the courts do, and that's why it's important to have everything in writing, legally, so it can be legally binding. And just because you incorporate in the state that you may not operate in, it may not work for you in the long run.
Just know there's so many big corporations
That do-
set up in the islands, set up the corporation in the islands, and they have no presence there, but they'll.
But they may have 1 or 2 employees there, and that's where you come in with this sufficient contacts. I have an employee here or an employee there, so why can't I work out of there, I have business there. It's for those who also, and again, that's up to the courts, but you also have those who say, I'm a P.O. box there, but you're never gonna see me there. I never travel to the state of Delaware, I never do any of that. Then you're gonna have a fight on your hands with whomever is suing you in the state of Connecticut. So they're gonna say, why should I go all the way to Delaware to sue this person or not necessarily have to go in state, because you can sue them here in federal court, and it's a whole, diversity of jurisdiction issue, but you can sue them in federal court in Connecticut, whereby the laws of Delaware would apply. So it's it's tricky, and I mean, it's too intricate to get into for this, purposes of this class, but it is, in terms of what you're asking, why shouldn't I go there versus here, it's not a simple answer.
I've sat in a number of different seminars where people were selling to incorporate in Delaware or Arizona, Nevada. Because when you open up one LLC in Delaware, you can open up 10 more sub-LLCs, and you're only gonna pay the $150
Whatever they,
a year and nothing for the other LLCs.
well,
So
and
there's,
that's what a lot of people like, it's a little bit more lenient, and the tax breaks a little bit, better for the owners, and the statutes basically are better geared towards the owners of the LLCs and corporations. But again, you have to have sufficient contacts. Does that mean opening up a storefront with having someone in there taking calls? Potentially.
They're not your food.
Potentially.
I think that's more of a problem now, being that you can have a virtual business.
Yes, yes.
So you could say, I have a presence everywhere.
Mhm. And then maybe they go, it depends on what kind of business you have, if you can have virtual, but then that means you don't have too many employees if you have a virtual business. So then maybe we get to where you domicile, what state are you domiciled in?
Or I could have a lot of customers in Delaware. I'm still here, but I could have a lot of
Right.
customers I ship there. It could be,
Mhm.
that just opens it up so much.
It does, it absolutely does. And that goes way beyond the scope of,
That's-
how do you structure, right.
I'll leave that
How
to
do
the
you structure
attorneys.
it here in Connecticut?
on the other side, that when you create your business and register in Connecticut, there's tons of support groups in different organizations that will help you if you're a Connecticut-based company.
Obviously, if you have a presence in Connecticut, your state will have, and that's kind of like any state, is if you have a presence in that state, they'll have an interest in contributing to the growth of your business, and especially small businesses, you can go to different, like you said, contributors or investors, or to try and have, contributions made to help build up your company, to help advertise your company, to help you with your
There's a lot of
company.
small business consulting groups that are sponsoring the nonprofit.
Absolutely.
That, will help you. If they find out you're richer in Delaware, go.
I'm not giving you my state money to go somewhere in Delaware, absolutely. That's when you're in registering your business, and it just basically what you decide, when you start to decide your own business, one of the first things you do is register with the state of Connecticut. Sole proprietorships, as we discussed, does not have to register with the state of Connecticut. But the other legal entities that we did discuss, they will be filed and formed through the Connecticut State of Secretary of State. The Articles of Organization for LLC, this document will be filed with the Secretary of State, and the filing fee just to get started is $120. It's always important to research the name of your LLC, because if someone has the same name, your Articles of Organization is going to be rejected.
Some places, if the names are similar, they won't let you do it.
Absolutely.
It could be a different name, but they'll say
But
it's
if
too
it's
similar.
too similar to someone else's business, because that means it's easier to get them, it's easy to get them confused. And so someone can think they're doing business with you, but they're doing business with X, Y, and Z, or they can think they're suing you, but really meant to sue X, Y, and Z. So it's basically a benefit to the business owners as well, to make sure that even competing owners, because usually the name of the business is the same, the type of services are somewhat similar. If the business name, it revolves around the type of service that they. Actually, I had just today, for whatever reason, we researched this business to make sure that my client's name, that you go on the Secretary of State site, you look on the Concord website basically to see if there's any other business registered under the same name as your business that you're looking to file. Well, my client's business was his name with his first initial, last initial, and carpentry at the end. And someone can file it a day before yours, or they can get in the mail at the same time, and they just open up theirs first, and there's gets taken first, so my client got rejected today and said, sorry, that name is taken, so you have to find another name. So he's not thrilled
Now,
about
what do you
that.
do if you want a name and someone's holding it? How do
Find
you-
another. You can't do it on the same unless you buy it from the other person.
How do you do that?
You gotta contact them and see if they're willing to even sell it to you, but if they've been, mind you, if they've been doing business under that name.
No, they're not doing anything.
They have it reserved, they can reserve it. If they can reserve the name with the Secretary of State, so if you know your name of your business, you're not ready to start the business now, there's a way you can just reserve the name with the Secretary of State, so when you are ready to start your business, you can have that name reserved for you. If they're not doing anything with it and they wanna sell it to you, or they want to basically dissolve their LLC so that you can use it, then that's possible too. But as long as that person holds it and they're paying their entity tax and it's an active status LLC, you have to find another name.
I just need to find an attorney.
But you want them to go and,
I want my name.
it's your name, your whole, your
What I
name?
want belongs to me.
So, let me get this clear.
No.
You had the name first, or you thought you had it first, and then that person went and started an LLC? Was it perhaps someone that you know?
I don't know who it is.
Oh, did you look it up on the Concord? I mean, it's easy to find out when you go into
I'll
Connect.
tell you after, I'll look it up.
Yeah, it's easy to find out who actually.
You can go to the Secretary of State's office, the computer right there, you can.
Actually, you can do it from your home computer. You get on the Concord website, you put in the name, and it'll tell you who the members are of the LLC, or who the owners are of the corporation, and their mailing address, or the address of their agent for service. So it's a way to get in contact with them if they were registered with the Secretary of State. Certificate of incorporation for a corporation is a $250 filing fee versus the $120 filing fee for the LLC. Certificate of limited liability partnership is $120, and the sole proprietorship, it's no fee. You file it with and some towns may charge you $5 or so to register it. And then if you have employees, you would proceed to apply for a federal state identification number so that you can pay your employees. In the last slides, and it's kind of small, so I've actually attached the actual forms on the very end of your packet, and those forms will be the Certificate of Limited Liability Partnership, and those are the actual forms that you would use to start your company. Those are what the forms look like, although our forms look a lot different because we draft them ourselves, but these are the standard forms from the Connecticut, the actual forms from the Connecticut Secretary of State. If you chose to do it yourself and you understood what it is that you're committing yourself to, you can do that. A lot of people fill it in, don't quite understand what they're doing and just going through the motions, and then they're LLC, but they don't understand the dynamics of it. So typically, we do our own forms, and we go over the forms with the client so they'll actually know what these legal documents they're signing and they're entering into.
So now, with a limited liability company, you can register it under whatever name you want, and you put your name as the principal,
As the member?
as the member. Do you need a secretary?
No, you don't have to have a secretary. You can be the sole member. You can be the only person. So you're the secretary, you're the treasurer, you're the managing member, you're it. You don't have to have that. But you can have that if you chose to.
Okay, so that's an option.
Right, so it's less formal. I mean, that's why it's less formal. You can have a secretary, you can have, you know, someone
I know
handle
with
your
the
finances.
S-Corp, you had to have a secretary.
Not necessarily.
That's what, you know, way back when.
Yeah,
Yeah.
not necessarily. But you know, like you can, and even with the LLC, you can have people that play dual roles. So you can have the member as the secretary, even if it's more than a single member LLC. So then you have treasurer, and in the corporation, obviously, you have all of those officers and then directors. And in your bylaws, it states how do you elect your officers, how do you, elect the directors, etc. Any other questions? Other than you just having to have that name?
Look, I want what I want. Especially if they're not using it, what's the point?
And